All right, so let's get more on this development. TVC News Judiciary correspondent Celestina Iria joins us from Abuja to help us put a context to this matter. Celestina, let me start with you. I understand I will also be having a lawyer, Jide Ologun, to discuss this. But before we get to you, Jide, let me first start with Celestina, who was in court. Well, it seems this is the end of the road for the People's Democratic Party. Can you give us a context on this matter?
I said that the suit emanated from the Federal High Court, then moved over to the Court of Appeal, now at the Supreme Court, where it was decided today. At the Federal High Court in Abuja, Justice Iyan Eko said that he lacked jurisdiction because the plaintiff did not have the local standing to institute the suit. He anchored his judgment in line with Section 29 of the Electoral Act, which says that it's only an aspirant of a primary election that can challenge the primary election. So far, so good. The PDP did not show the court any reason as to why harm will be done to them or injustice was done to them considering the nomination of KAshim Shettima. And the court also said that that particular suit brought by the PDP at the trial court, which is the Federal High Court, was caught by the principle of Estapo Judicatur, which says that, which is a principle that stops adjudication of a particular case which has already been decided. There is a judgment, a subsisting judgment of the Federal High Court that had already decided on this very case before the PDP brought the case to the Federal High Court. The PDP, dissatisfied with the judgment of the trial court, moved to the Court of Appeal. The Court of Appeal also dismissed the PDP's appeal and awarded the cost of 5 million naira, still also citing the position held by the trial court, where it says that the PDP, they were meddlesome interlopers, busybody. They had no locus to first of all, in the first place, institute the suit against the president and the vice president-elect. Now, at the Supreme Court today, the Supreme Court was extensive in its judgment. It cited examples as to why the suit failed and was bereft of merit, and the court lacked the jurisdiction. Firstly, the court talked about the stand, the PDP, to bring the suit. The PDP anchored the suit on, said that the vice presidential candidate, or I beg your pardon, the vice president-elect is in violation of Section 29, Section 33, Section 35, and Section 84 of the Electoral Act. But the court today said that Section 29 does not apply because the PDP were not aspirants in the primary election, the nomination. And so far, so good. What the court said that the vice president-elect submitted his resignation or a letter to the party stating them that he is withdrawing from the race of being a senator and accepting the nomination of the vice president. According to Section 142 of the Constitution, his appointment is an associate of the president, so it has nothing to do with double nomination. They also made reference to the case of Uche Wonsu in 2018 and the judgment delivered by the Supreme Court. That case did not apply because Uche Wonsu, as the Supreme Court found today, was a candidate of two political parties. He was nominated by two political parties, not the same political party. But the court also took us back and gave an example of 1999, wherein Atiku Abubakar won the governorship election in Adamawa State and also got nominated to be the vice presidential candidate of the PDP to run alongside Olusegun Obasanjo. He abandoned his ambition of becoming the governor to pursue his ambition of becoming a vice president. But his deputy wanted to step in as governor or inherit that position, where the INEC had challenged that saying that they would conduct a re-election. But he went to court, or to the Supreme Court, and he got judgment. So the justices of the APC court today asked the PDP that what has changed from 1999 to 2023, that now they are coming to challenge the candidacy of KAshim Shettima, seeking the nullification of Bola Tinubu's election. So the court said there is no basis at which it will grant the reliefs that the PDP is seeking, that the PDP has no stand, the appeal lacks merit, and the appeal was even statute barred because the 180 days prescribed by the lower court and the 60 days by the appellate court to decide on this case have elapsed.
All right, Celestina Iria, thank you so much for that insight.